Good afternoon, everyone. My name is Preet Bharara, and I'm the United States Attorney for the Southern District of New York. Today, we unseal federal criminal charges against two former traders at J.P. Morgan Chase & Company, the largest financial holding company in the United States and the parent of the nation's largest bank. We have filed conspiracy, wire fraud, and related charges against these two traders for their alleged participation in a scheme to hide the true extent of massive losses in a synthetic credit portfolio maintained by the Chief Investment Office of J.P. Morgan. All told, as the world now knows, those losses ultimately reached over $6 billion. The named defendants are Javier Martin Artajo, who served as a managing director and head of credit and equity trading in that office, and Julian Grout, who was a vice president and a derivatives trader in that office. As the complaints describe, at the heart of this case are alleged lies and misrepresentations about the fair value of synthetic credit derivative products, and in particular, credit default swaps on JPM's books. Now, while the transactions and financial products involved may be complex, the criminal conduct alleged is simple and straightforward. The defendants deliberately and repeatedly lied about the fair value of billions of dollars in assets on J.P. Morgan's books in order to cover up massive losses that mounted month after month at the beginning of 2012. Those lies misled investors, regulators, and the public, and they constituted federal crimes. As has already been conceded, this was not a tempest in a teapot, but rather a perfect storm of individual misconduct and inadequate internal controls. We also today announce a cooperation and non-prosecution agreement with another former trader at J.P. Morgan, Bruno Ixel. Now, before I get to the charges in some detail today, let me introduce our partners in this prosecution and investigation, which began well before the Senate issued its very thorough report this past March. These are, by the way, as you may appreciate, difficult cases to investigate and to piece together, and the only reason we're here is because of the fine men and women who are career prosecutors and investigators and enforcement lawyers who literally pored over thousands of pages of documents and interviewed dozens of witnesses and built this case through sheer hard work. And I am joined today by our partner, the FBI, in this case and in so many cases led by George Venizelos, the Assistant Director in charge, and represented here today by April Brooks, the Special Agent in charge of the Criminal Division of the New York Field Office, and her excellent team at the FBI, which includes Doug Leff, Mario Pisano, Dave Shavs, Matthew Taylor, Jonathan Polanitza, and Salvatore Cincinelli. And I want to thank them for their incredibly hard and dedicated assistance. We're also joined by George Kanellis, the co-director of the Enforcement Division at the SEC. I want to thank him and his team for all their great work in getting to this point as well as Andrew Calamari, director of the New York office, Michael Osnato, assistant director of the New York office, and they're always a great collaborator on these kinds of cases as well. And last but certainly not least, I want to thank the career prosecutors in my own office who are standing here. They are Eugene Angolia and Matthew Schwartz, the assistant U.S. attorneys handling the prosecution, and their chiefs, Anjan Sani and Mark Berger. Now, let me take just a couple of minutes to talk about the particulars of today's charges. First, as I mentioned, the two defendants were traders at JPM's Chief Investment Office, or as it's known, the CIO. What was the purpose of the CIO? Well-functioning banks have excess deposits, meaning the difference between the amount of money put in by customers and the amount of money lent out to other customers. In JPM's case, that differential in 2012 was a whopping $350 billion. Which is, by the way, more than the GDP, I think, of many countries. In JPM's case, the responsibility for wisely managing that $350 billion resided with the CIO. Now, within the CIO, there were various portfolios. One of them was called the SCP, or Synthetic Credit Portfolio. Since at least 2007, J.P. Morgan's CIO invested a part of its money in risky, complex credit derivative products. That synthetic credit portfolio grew dramatically in size over time and was extremely profitable, generating approximately $2 billion in gross revenue It was profitable, that is, until 2012, when things began to go south in a pretty big way. And that's where the trouble began, culminating in today's charges. As alleged, the defendants violated, in essence, their obligation to honestly value the bank's assets. Banks that trade in these sorts of risky products are required to record their daily assets and liabilities in an honest way by marking the positions to their fair market value, known in many circles as mark-to-market accounting. According to both U.S. generally accepted accounting principles and also J.P. Morgan's accounting policy, the fair market value for the derivatives traded in the CIO was the price at which traders could actually sell their positions, which makes sense. But these products, as you may know, don't trade on an exchange. So traders are required to make determinations of the fair market value by looking to a number of objective data points. Prudent and accepted practice is to value derivatives between the bid and offer prices generally available in the market, typically close to the midpoint. J.P. Morgan's own accounting policy provided that the, quote, starting point for the valuation of derivatives portfolio is mid-market. And that's exactly, in fact, what executives at the CIO did. They were at it near the midpoints, sometimes referred to as the crude mid, until 2012. And that is when things took a turn for the criminal. You see, in 2012, the SCP, that portfolio I mentioned, began to lose money at a rapid and alarming pace. Approximately $130 million in January and another $88 million in February. Why? Because traders made big bets in those derivatives, but the market ended up turning violently against them. And so, as alleged, to cover up mounting losses and under pressure from above, beginning in at least March 2012, the defendants began to creatively cook the books. They summarily abandoned the valuation methodology dictated by common sense, by prior practice, and by sound accounting practices, the methodology, incidentally, used by JPM's own investment bank. Moreover, as alleged, the defendants knew they were cooking the books with respect to valuations because they separate and apart from what conduct I'm describing, they separately kept meticulous track of what the valuations would have been had they not lied about them. The hope was that the bets would turn around, but they didn't. And as the bets continued to sour, rather than scale back and come clean, the defendants allegedly doubled down, not only on their bets, but also on their fraudulent valuations and on their cover-up. If you take a look to the chart on my right for a moment, you'll see reflected here a lot of what is in the detailed complaints that were unsealed today. As I mentioned, beginning in January of 2012, the CIO had to report a $130 million loss. And then over time, based on pressure from Martin Artajo, according to the complaint, and instructions from Martin Artajo, according to the complaint, people were instructed not to show additional losses and to change the marking methodology, to change the valuation methodology. As of March 15th, as alleged in the complaint, the mismarks or the changed valuation was so large that according to their own separately kept spreadsheet that said what the valuation should have been had they been doing it the way they always had been, the gap at that point in March was already at $292 million. By March 30th, according to a later analysis that the bank asked its own investment bank to do, using a reasonable methodology in their view, to figure out what the gap was between the way people in the CIO were valuing the assets and what an appropriate methodology would have been, they came up with a gap after the fact of $67 million. And as everyone knows, the bank had to significantly understated its first quarter losses within that derivatives portfolio and had to ultimately restate its first quarter net revenue to the tune of $660 million. And throughout, as set forth in the complaint, and I won't repeat this here, conversations and chats between and among the people who were identified in the complaint about whether or not this was a wise thing to do. At one point, the CW, Mr. Ixel, says, I don't want where he wants to stop. I don't know where he wants to stop, but it's getting idiotic. Those are the words of Mr. Ixel. So, how did this happen? Which is a reasonable question. Where were the internal controls? To be sure, the CIO had a valuation control group whose job it was to serve as an independent and rigorous check on the traders' asset valuations. But as alleged in the complaints, that group was neither independent nor rigorous. In fact, it wasn't even really a group, as it was staffed in London with essentially a single employee, and as alleged, the value control group regularly tolerated wide discrepancies between traders' marks and the control group's own independent valuations. Let me end by just saying a couple of things. The difficulty inherent in precisely valuing certain kinds of financial positions does not give people a license to lie or mislead or to cover up losses. It does not confer a license to create false books and records or to make false public filings. And that goes double for handsomely paid executives at a public company whose actions can roil markets and upend the economy. Capitalism works best when its captains do not lie and cheat. Capitalism works best when its biggest beneficiaries play by the same rules as everyone else. We happen to live in a time where not just one bank, but one trader within one bank can do catastrophic economic harm in practically the blink of an eye. And recent history bears that out. And that is why prosecutors need to be even more aggressive. Regulators need to be even more vigilant. And as I have been saying for some years now, companies themselves need to pay closer attention to the cultures that they create. And now it's my honor to call to the podium April Brooks from the FBI.
Good afternoon. The complaints tell a story of a group of traders who got in over their heads and to get out, doubled down on a series of risky positions. Javier Martin Artajo and Julian Grout, who in prior years had turned profits as high as $1 billion, sought to exceed the high expectations of JP Morgan for the portfolio they managed. In the first quarter, as been said, of 2012, boom turned to bust. Losses mounted and hedge funds shorted the bank's massive position in their synthetic credit portfolio. The defendants, concerned about losing control to other traders at the bank, fudged their numbers on a daily basis, and in some cases, completely made them up. Martin Artajo not only approved of this, he alleged the bank's chief investment officer also supported this reckless behavior. Month after month, to provide themselves more time to exit their position, the defendants increasingly exaggerated the value of the synthetic derivative the bank held. Martin Artajo and Grout were required by law to make and keep records in reasonable detail of the positions JP Morgan held. Obviously, they ignored the part about keeping those books fairly and accurately. They grossly inflated the value of the bank's synthetic derivatives. It brought a whole new meaning to cooking the books. Buckling to pressure from JP Morgan's chief investment officer, Artajo and Grout continued to manipulate the positions in their book to show smaller losses than actually occurred. These records were eventually filed in the bank's quarterly report with the SEC. As losses mounted, JP Morgan moved aggressively to defend the position in the bank's defend the position in the bank's synthetic credit portfolio. Simply put, the traders thought they could buy their way out of their problem. You would think one of the biggest banks on the street would have rigorous compliance and oversight over their books. Think again. As described in the complaints, compliance over the bank's portfolio was little more than a rubber stamp. Compliance in name only. JP Morgan's valuation control group relied on market views and price quotes from the very group of traders they were supposed to be overseeing. Banks and financial institutions who believe they don't need to conduct meaningful oversight should think again. This should be a warning to bankers and traders everywhere. Integrity and probity cannot be sacrificed in the pursuit of income and profitability. As today's announcement shows, it's just not worth it. Breaking the law by cooking the books is a recipe for imprisonment. The integrity of our markets and our banking systems are critical. The FBI will continue to investigate these cases so long as people fail to heed that warning. I want to thank United States Attorney Preet Bharara, who has been an invaluable partner in bringing these cases, Deputy United States Attorney Rich Zabel, and Assistant United States Attorneys Eugene Ingolia and Matthew Schwartz. This investigation wouldn't have been possible without the tireless work of FBI Special Agents Matthew Taylor, Sal Cincinnelli, and John Polonitsa. Thank you.
Thank you, April. Now, it's my honor to bring to the podium George Kanellis, a co-director of the Enforcement Division at the SEC and also an alumnus of this office.
It's good to be here. I'd like to thank the U.S. Attorney for the Southern District of New York, the New York Field Office of the FBI, for their characteristic, outstanding coordination with the SEC in this unique and challenging investigation. The case involves improper valuation, as you've heard, of extremely complex and exotic instruments contained in a trading book that had grown to the gargantuan size of $157 billion, conducted in secret with lax supervision, directed at the U.S. from outside the country. Combine that with massive shortcomings in J.P. Morgan's internal control infrastructure, and you have the makings of a storm that hit when the wrong way bet that was taken by these traders began to unravel in early 2012. We have charged the defendants with securities fraud, with circumventing the internal controls of a U.S. public company, with falsifying the books and records of a public company, and with related aiding and abetting charges. Preet has already explained the details of the mismarking by these traders, so I want to provide some background on how an intricate case like this is made, the work and the expertise required to put together a case like this. Our first task was to immerse ourselves in the market that these traders lived and breathed every day. When you're talking about highly complex credit derivative instruments, this is no easy task. Over the last few years, our enforcement division has recruited to the government some of the best and brightest experts and specialists from Wall Street, including credit derivative traders, risk managers, structured products experts, and experts in corporate governance. Working together with our attorneys and accountants, this group, literally within days of J.P. Morgan announcing the $2 billion trading loss in May 2012, had set the roadmap for the case that's brought today, sifting through tens of thousands of dealer pricing runs and other market data, reconstructing in real time the trading book and the turns of the market that provided vital context for hundreds of hours of taped phone calls and electronic chats that occurred among traders as the trading book grew to its staggering size and began a plunge in value in 2012. On the surface, it can seem innocuous for a trader to decide to change the price used to value a security by fractions of a basis point, fractions of 1/100th of 1%. But these decisions can cause profit and loss swings of hundreds of millions of dollars. If law enforcement does not have the critical expertise to test these minute price movements and expose them as illegitimate and intentionally fraudulent, then mismarking cases like this one and others, including the recent CSFB case that was brought by a team that includes many of the same members of this team, would be extraordinarily difficult. I want to close by emphasizing that our investigation is continuing, and I'd like to recognize some of the SEC staff who have been doing all the work behind the scenes to review millions of pages of documents, technical trading data, and hundreds of hours of recorded calls. These individuals, under the leadership of Andrew Calamari, head of the New York Regional Office, Steve Rawlings, and Michael Aznato, assistant regional directors, include Pete Altenbach, Josh Brodsky, Joseph Boroshansky, Chris Mealy, Daniel Michael, Eli Bass, Kapil Agrawal, and Dan Nigro. And thanks especially to the U.S. Attorney and the FBI for representing the very best of law enforcement. Thank you.
Thank you, George. We're happy to take your questions. Yeah. The two defendants have not yet been arrested. Prosecutors from our office have been in contact with the lawyers for each of those defendants, and we are hopeful that they will do the right thing and present themselves in the United States to face the charges that have been brought. Yeah.
One of them is in France, the other one is away on vacation. So how does that change things? How does that make it difficult?
As I said, they are not yet in custody, and we have had communications with their lawyers. And just to repeat what I said a second ago, we're hopeful they'll do the right thing and come here and face the charges. Yeah.
What kind of sentences could they be facing if they
We're getting a little bit ahead of ourselves, but the maximum charges on the maximum penalties on the criminal charges are, I believe, 5 years on the conspiracy and 20 years on the others. Yeah.
Do you have any indication that the knowledge of these misstatement of the numbers went higher up in the management beyond the chief investment officer?
Yeah.
Did any of the bank's top executives know about this in real time?
I'm not going to go beyond what's in the complaint, and there are various allegations in the complaint. I'll repeat what Mr. Cannella said with respect to the SEC investigation. Our investigation also remains open. Yeah.
You talked about, the complaint talks about Martin Arnaujo saying that this is what New York wants. You talk about pressure from the CIO. So I guess, does it speak for itself that this may have gone higher up at JP Morgan? What does it say about the internal controls? And in the end, did the bank report suspected criminal activity to you, or did you have to come?
Well, I think I'll repeat what you said at the beginning, which is that the document speaks for itself. As I said, the investigation remains open. The allegations in the complaint do speak for themselves, and I'm not going to get into who did what first, but I think as people know in the world that there were a lot of press reports about what was going on within the bank almost as soon as it happened, and that everyone jumped on it quickly. Mr. Knelson made that point about the SEC. The same is true for the FBI and the U.S. Attorney's Office. Yeah.
The CEO and CFO of JP Morgan liabilities under Sarbanes-Oxley, confirming to make sure that the filings are accurate. What is their exposure or the SOX to either civil or criminal cases?
Yeah, again, I'm not going to talk about what else may happen in connection with this case. Mr. Knells can also talk about this from the SEC's perspective. These are the charges that we have brought now, and the investigation remains open. Yeah, ooh, back there.
You used Jamie Dimon's own words that he used on a conference call and sort of turned it around. Should he have known, or should higher ups have been more compliant with the standards generally accepted?
Yeah, I'm not going to go beyond what I've already said. You know, multiple speakers up here have talked generally about how compliance is important. I have taken it separate and apart from this case, talking more generally about institutions, whether you're talking about Albany, or you're talking about firms on Wall Street, or you're talking about retailers on Main Street. Culture is important, and you know, a culture of integrity is important at those places. And the important thing, from the perspective of the people up here, who are, before we are prosecutors and regulators and FBI agents, are Americans, and we would prefer not to see bad things happen. And when there are better controls in place and there's better culture in place, again, whether you're talking about, you know, a political institution or you're talking about a corporate institution, it would be better if those things didn't happen in the first place. And in case after case that we have seen, that I've seen in a little bit over 4 years of doing this job, you worry that there's not as much of a good culture at a lot of places as there might be. And it does matter. Yeah.
You brought up culture. From previous investigations, we know that Ina Drew, who was overseeing Martin Arnaujo, had shut down trading in March on this trade. And she had quizzed him, and he'd also been quizzed by accountants and auditors. So what leads you to believe that it was culture as opposed to, you know, a rogue group of 3 or 4 traders?
Yeah, I'm not making any definitive statement about culture in this case. What I'm saying is, as a general, and by the way, whether or not you're going beyond, you know, a certain group of people, there are a group of people who are alleged to have been part of this, and you know, that's a group in which the culture was not great, as evidenced by the allegations that we're specifically making against identified people. But I'm not going to go beyond what's in the complaint. Patty.
Yeah, the complaints seem to describe that Mr. Ixel was basically reticent after originally participating in this scheme to Miss Mark. He becomes reluctant and starts sending messages and information to superiors at JP Morgan. Is that why he gets the non-prosecution agreement, which is extremely rare to obtain?
Yeah, non-prosecution agreements, as people who cover our office should know, they are rare. And there are a number of factors that go into a determination about that, and there's a lot of deliberation about that. And among the factors that go into it are relative culpability, degree of cooperation from the individual, whether or not you could otherwise compel the individual to testify, given circumstances like his citizenship and location, given whether or not those things that he or she is testifying about and can provide information about are corroborated, whether or not that person actually was a voice for reason within the institution, and whether or not that person raised some red flags. And I think, again, on this point, as on most points, the complaint speaks for itself, and there are numerous examples of occasions where Mr. Ixel, although I don't think you could call him blameless, did sound the alarm more than once. Yep.
You mentioned that the defendants earlier just now, you mentioned that the defendants acted under pressure from above. Will you be investigating that specifically?
Yeah, we investigate everything that it makes sense to investigate, so you should assume that we're investigating everything that it makes sense to investigate. Yeah.
What can you tell us about the defendants' motives, why they acted as they did, why they wanted to cover up these losses as they kept them out?
Well, usually we don't speculate about motive, but it's actually part of the complaint in this case that, and as I described in my remarks and as others have, what you had was massive losses, as alleged, in a particular portfolio, and there were people who were involved in that and responsible for those bets and those losses who wanted to figure out a way to turn it around before it became known widely to the public, to investors, and to perhaps others within the bank. And the goal was to cover up those losses for a period of time, hoping that they were going to make good on it, and nobody would have known that alleged fraud had been taking place. So it's these are complex and somewhat exotic financial instruments, as Mr. Kanellis described them. But at base, it's a classic story of people who were doing something funky and then ended up realizing they were holding the bag and tried to get around that by lying about it for a period of time so they could make things right, which didn't work because the bottom fell out. Yeah.
If these two don't come here and give themselves up to cooperate with you, would you go down the extradition route, and do you fear that that's where this case may ultimately go cold?
Yeah, we always undertake all options that we have. In some cases, people come voluntarily. In other cases, people get extradited. And we brought the case because we think it's an important case, and we want to bring people to justice, and people deserve their day in court because they're presumed innocent until proven guilty. And so again, we'll pursue any option that makes sense and that's legally feasible. But our hope remains that these individuals will come here and face the court. Last question. Yeah.
When you say that the investigation is open, would it be fair to say that other executives of the company itself may still be under investigation? Would that be a fair statement?
Yeah, I mean, generally speaking, our investigations deal with people, and so if the investigation is open, then I think it's fair to say that there are other people who may be under investigation, yes. Thanks, everybody.